To see the benefits of ADR, we need to compare it to the traditional court system, so let's do that now. Firstly, ADR involves less costs and less time than traditional court processes. With traditional court processes, the employee and the employer would have to pay hefty legal costs such as lawyers' fees, expert fees, and court administration fees, as well as court cases taking up to months or years to resolve, whereas ADR resolutions can be reached in weeks or months. This means ADR is less disruptive to the lives of the parties, so the employee can go back to work quicker and the employer can focus on their business. Another benefit of ADR compared to the court system is that parties have more control and autonomy over the process. They can choose which type of process to engage in, they can offer solutions and options and come to outcomes themselves rather than via a judge. Because parties agree on procedure and outcomes, the negotiations will likely be conducted in good faith, whereas any outcomes reached will be more durable because parties are more willing to stick to decisions that they make themselves. The ADR process is also less formal, less stressful, and less intimidating to the parties. Because of the informality of ADR, parties also get to speak more and address concerns important to them rather than just focusing on the legal questions of the dispute. ADR is also more private in that only parties invited to the ADR process can attend. ADR is also beneficial in preserving working relationships because it allows decisions and solutions to be made based on win-win outcomes rather than win-lose outcomes like the traditional adversarial court system. Lastly, and most notably, ADR is very effective in enabling access to justice, particularly for vulnerable and low-income workers who don't have the necessary finances and resources to engage in traditional court processes.
How important do you think ADR is in resolving workplace disputes in Australia's employment law landscape? And what would kind of the context of industrial relations, employment law look like without the use of ADR?
Yeah, that's a really good question. How important is it? It's absolutely critical. There's been plenty of disputes I've been involved in, particularly when I was working for unions, that were getting bitter or nasty or heading towards quite expensive and complex litigation that were resolved by a deft hand in dispute resolution, a good mediator. For example, or looking at examples, I had one recently. At the moment, there seems to be a lot of restraint of trade disputes on. People are moving around with this current employment market. I had a very bitter one involving some serious parties, some big money, just recently. And on the suggestion, I must confess, not of me, but of my opposing counsel, we went to mediation. I thought there was no point, but admittedly, at 7 o'clock that night, we had a deal, and everybody could walk away. Now, the amount, just looking at it purely on legals, and that's before we start considering the business realities of what would have happened if everybody went off to court and we had a decision. Purely on legal fees, people save tens of thousands of dollars. That's just on the most basic of estimates. So, incredibly important from a cost perspective when it comes to businesses and employees, and also incredibly important for whether it be industrial or employment harmony and unity and making sure we can keep on going. If we didn't have those processes, to answer the second part of the question, the only people that would win would be people like me. I'd probably have a much nicer house because at the end of the day, we'd be off at court all the time, fighting over things and what have you. So that's how important is it? They're absolutely critical, ADR processes.
Yeah, but I think adding on to that, without ADR, I guess that kind of sometimes there's that unequal power imbalance between the employer and employee, and I guess without ADR, that would just be exaggerated in terms of favoring the the party with deeper pockets.
Indeed, and there's that element. There's also the element of the fact that the moment you start going off to court, people start making rash decisions and things like that, the ADR process can really make people realize and crystallize. A judge isn't going to tell you how hopeless your case is. They're just going to make a decision. But a good mediator or a good conciliator will manage your expectations and help your lawyers, through that process and hopefully come to a more sensible conclusion. Other than sort of cost and time savings, which are the obvious ones, if it's a dispute between a trade union, for example, and an employer, employees, or an employer and trade union, that's what I was correct the first time. They're ongoing relationships. And so, sorry, I'll try that again. So when you're looking at relationships that are ongoing, employees, employers, they're ideal to have ADR in place, because at the end of the day, you need to manage that relationship, and that relationship, will go on for a long time. If you're looking at, for example, BHP and the Australian Workers Union, they've been working together for hundreds of years. The Shopkeepers Union and Woolworths, they've been working together again for, I don't know how old Woolworths is now, but really since Woolworths has been around. So, you want to build those relationships and keep them going. So there is, there's a cost saving, but there's the reality of it. You don't want to, nobody wants, and nobody really wins out of a relationship that was like Qantas in 2013 and those, I think it was the 5 unions, the pilots and the baggage handlers and the flight attendants and the ASU and all that. You don't want that relationship. You certainly don't want a relationship like we saw on the waterfront in the late 90s. And again, there was the lockout at Hutchison, back in 2015 or whenever it was. And again, it's just not good. I've been to those picket lines. They're not fun places to be. It's actually it probably was about five or so years ago. Now, and you've got people living in caravans that are standing around freezing to death, while the employer is losing money, and boxes aren't coming off ships and things like that. So that's a huge thing. Another thing, and this happens probably on that's sort of on the big level when you've got those relationships between employers and unions and employees, and they're continuing. But what I find as well on those individual disputes is you can have, even if the relationship is ending, you have often a certain closure for both parties that can't be quantified in money. I had a very early on in my career at working for the Transport Union, I had a mediation. I don't think I'll ever forget it. It was before a federal court registrar, and it was an owner of a trucking company, and my client was a truck driver. And the mediation was going nowhere. Myself and the other lawyer were sniping off. And the owner of the company, who was an ex-truckie, he's a self-made sort of fellow, and he got up and said, "I've had enough. I'm going to go and talk to this bloke by myself." And myself and the lawyer just didn't want it. And I was a lot younger and perhaps a little sillier, and got told where to sit by him. And the mediator said, no, just let him go. I don't think they're going to start punching each other, and I'll keep an eye on that. And they went off into another room. I don't know what was discussed. Went on for hours. And again, I wasn't allowed in the room. The other lawyer wasn't allowed in the room. The only report I got back from the mediator was, I'm pretty sure they'd been crying. Oh, goodness. And anyway, what happened was the matter was resolved. A very good sum of money was paid to my client. I don't know how they got to that figure or anything like that. But at the end of it, my client was telling me about how he had disclosed certain conduct of other employees and managers and how things were running, and the owner of the company just didn't know about that. That's what he was telling my guy, at least. And both of them sort of really came to a conclusion where the relationship had broken down. He was never going to work for that company again, and he didn't want to. But at the end of the day, he got to say his bit. He got to tell his truths to the manager and the owner, and the owner and the manager got to tell his truths to the employee as to why he got sacked and all that sort of stuff and how he saw it. Now, who knows? Maybe the manager went back and all the problems never got fixed. But at least from my client's perspective, he got a great deal of pleasure from it. And often you see that even on an individual level. And so I think that the restoration or the conclusion of a relationship through an ADR process properly executed is worth a hell of a lot more than any of the money or other settlement, practical stuff that we talk about.
Yeah.
And that happens in a lot of cases. In a lot of cases, that's an example. But thank God I don't have to deal with my boss anymore. I'm glad it's over.
Yeah, but definitely one of the huge benefits of ADR is that the parties are more interactive rather as opposed to being in court. And I guess ADR gives a greater avenue for, as you said, even though the relationship was concluded, it still felt like a bit of a win-win. Whereas, court, it might feel a little bit more win-lose, that kind of situation. So, yeah, it's awesome.
Yeah, no. And the moment you're in court, I'm somebody like me standing between the clients. And then you've got a solicitor, and sometimes you're in a really high stakes environment. I've talked about restraints. You go from nothing to a hearing in a week and a half's time, and everybody's very stressed, and you've spent literally tens of thousands of dollars. And you're all wedded to your points, but if you can talk to each other, well, sometimes you can save yourselves a hell of a lot of money and get that closure.
How important do you think these processes are in resolving the workplace disputes you've been involved in, and why? What benefits does it give? And what would the landscape of employment law and workplace disputes look like without ADR?
Right. Well, let me perhaps contrast that with this example, right? So the local court tends to process matters in an arbitrary fashion. So it tends to move fairly quickly through cases.
Mm-hmm.
It doesn't sort of give parties too much of an opportunity to sort of go off and get lost in in Never Never Land or legal Never Never Land, right?
Mm-hmm.
So they tend to sort of move fairly swiftly. Even in that jurisdiction, the judges or magistrates will allow for parties to sort of go out of the court, out into the foyer area, and have some discussions to potentially try and resolve the dispute, and then come back into the court and address the magistrate and see if they've been able to resolve their dispute without the court's intervention. Right? So that practice even happens today within the local court jurisdiction.
Yep.
What the Fair Work regime does is it codifies and tries to put some extra structure around that process.
Right.
Of saying to parties, hey, not only am I directing you to go off and have a bit of a conversation, but hey, this is how that conversation should proceed.
Right.
Okay. And it tries to impose on the parties a kind of framework that allows them to tease out their issues,
Yep.
And try and be able to sort of resolve what those issues are on an interest-based approach.
Okay.
So, in other words, rather than sort of me, parties coming together and saying, "Oh, well, I aggrieved because you didn't write to me or you spoke to me in a bad way," rather it sort of tries to cut through all of that emotion and get really to what the nub of the problem is, which often tends to be interest-based, such as, for example, you require us to start work. And again, I'm sort of giving you this as an example, right?
Yep.
You require us to start work at 9 o'clock, but in order for us to be able to start physically working at 9 o'clock, we are then forced to have to come into work by no later than about 8:20, so we can then speak to the previous shift and work out exactly where they were up and what was happening within that. So that's half an hour of work that we're not doing or that we're not getting paid for, right? And that creates conflict. So rather than us being able to do that, what you should do is allow us to start work, at 8:30. So in other words, pay us to start working at 8:30. So
Yeah.
we're not paying out of pocket for that half an hour that we're working.
Mhm.
And that means when we do start at 9 o'clock, we then can be as productive as we would be at 9:30, where otherwise we would start at 9 o'clock. So
Yeah.
it allows for parties to be able to sort of sit down and unpack what the real issue of concern is for them, how they are personally affected by that issue, and what then can be done to resolve that issue.